attorneys general who stood together to hold the social media giant accountable to the law and the harm it's created. Bipartisan isn't something you hear too often these days. It speaks to the fact that protecting our children isn't and should not be political. It's a priority. It's our duty. It's a North Star for us. I also want to express my gratitude to the members of California DOJ's Consumer Protection Section who have worked tirelessly on this case for years, head down, sleeves rolled up, just getting the work done, from the investigation to filing the complaint to discovery and to a powerhouse performance at trial starting last week that I couldn't be more proud of. Our team, I'm biased, I know, but our team did very, very well and made me very, very proud. And the trial did not go well for Meta. These extraordinary public servants have dedicated so much to this case, and it shows. I know some of them are on fumes today, needing a little more sleep, and I know and hope they'll get it soon. But I couldn't be more proud of the collaborative effort from my team, from teams across the country, from a bipartisan set of attorneys general, holding Meta accountable and delivering for our children, our parents, and our families. To briefly recap, we sued Meta over claims that it designed and deployed harmful features on Instagram and Facebook that drive compulsive use and harm young users' mental health, and that the company knew about these dangers and lied to teens, to parents, and to the public about them. We believe the proposed settlement filed today addresses some of the concerns at the core of our lawsuit and that it will force transformative changes necessary to protect our children. And importantly, these changes will be made within months, no more waiting. For all users under 18, Meta has agreed to set a default daily time limit of 2 hours that will drop to 1 hour if other social media platforms agree to similar terms. Set a default block between midnight and 6 a.m. when our children should be sleeping, not scrolling. Set a default block on notifications between 10 p.m. and 7 a.m. and during the school day, again when our children should be sleeping and studying, not scrolling. The company will create an enhanced mechanism for teens to report potentially harmful content and has agreed to respond to 90% of those reports within 6 hours. Meta will set a default ban on displaying the number of likes or reactions to posts and a ban on cosmetic procedure filters, plastic surgery filters. And it will have an option for users to choose a non-personalized feed, meaning a feed that doesn't use an algorithm to target them with content aimed to keep them endlessly scrolling. Those are some of the changes to the platforms. Meta has also agreed to maintain, review, and improve existing teen content safety measures and will create enhanced parent supervision tools. It will institute robust age assurance measures to detect users under 18, and it will develop ways to identify and remove kids under 13 from their platforms entirely. Meta will bring on an independent auditor with expansive access to information and resources, regular reporting, and the right to communicate with our offices. That's critical to us to maintain accountability, oversight, and make sure that Meta delivers on all of these legal commitments. Finally, Meta will be subject to an injunction prohibiting it from making further false, misleading, or deceptive statements around its safety features. In addition to platform and policy changes, Meta has agreed to pay the states joining this agreement up to $17 billion over 10 years. California alone will receive $1.5 billion to $2.1 billion if this settlement is approved by the court. How the majority of this money will be spent will ultimately be decided by the legislature and the governor, but it is earmarked in the proposed settlement for purposes related to the prevention or remediation of mental health or other harms to young Californians associated with social media use. From the beginning, this case has been about protecting young people, our children, our future, online. The data is clear. More time on social media tends to be correlated with depression, anxiety, body image issues, susceptibility to addiction, and interference with daily life, including learning. If you're a parent like I am, or a guardian, or a teacher, or a healthcare provider, sadly, you've likely seen some of that play out in real life. We protect our children from so many daily dangers, but we can't adequately protect them from harms Meta hides and lies about, or from designs that are built to suck our children in. With this settlement, that is changing. In the coming months, our children and teens will be safer on Instagram and on Facebook. As big as Meta is, it doesn't stand alone. We're continuing our fight across social media, including our litigation against TikTok. And we'll continue to demand better from all parts of this industry through our ongoing work with the legislature, our defense of SB 976, California's social media algorithmic harms bill, from continuing industry challenges, and through our enforcement work under California's existing consumer protection and privacy laws. We'll continue to do all we can to ensure our children are safe online, no matter what platform they log into. I urge other companies to take note that our door is open. I've said it before and I'll say it again. I'm always willing to come to the table for honest, good faith negotiations. I'd much rather work with California's business community than have to take them to court. We want innovative companies to continue to grow in our state, contribute to our economy, advance our nation, and employ our people. We just expect them to follow the law as they do. Innovation isn't a free pass to do as you please and hurt our people along the way. At the end of the day, the mission is simple: protect Californians and uphold California law, and to stand with California children, teens, and parents when companies put them in harm's way. If we have to go to trial to do so, we absolutely will. I'm glad that with this proposed settlement, we were able to find common ground and, if we receive court approval, secure the wins California sought to protect our children for years to come. Before I open it to questions, I want to again recognize the individuals on my team who stood up for California families and children. They aren't here for the glory, and I'm sure I'm about to embarrass them, but they deserve the accolades, and I want to give them the credit that they deserve. Megan O'Neill, Josh Olszewski Jubileer, Neha Aurora, Casey Reed, Sam Beckett, Pauline Ryan, Jordy Hefcart, David Beglin, Jake Fernandez, Robbie Matson, Michael Koseng, Emily Kalanithi, Barney Eskandari, Tina Charanpong, and Nick Akers. An incredible team working overtime to deliver amazing results for our children, for our families, for our state, our country, and our future. Thank you to each and every one of them for their incredible work. With that, I am happy to answer your questions.
If you'd like to ask a question, you may do so by hitting the raise hand icon at the bottom of the screen. You can also submit questions through the Q&A feature. Please state your publication when we call on you. First question comes from Ethan. You're now unmuted.
Hi, it's Ethan Barron from the Mercury News. Thanks. Hey, so you mentioned this addressed some of the issues of concern here. What did you compromise on with this deal, and what still needs to be done?
I don't think we compromised on anything here, but there's always more to do. This is a really strong down payment, if you will, on protecting our kids. It is transformative. It is a watershed moment. It is a milestone mark. Mostly what needs to be done is getting similar protections across the industry with TikTok, with YouTube, with Snap. Meta is a major player, and this is an incredible result. But there's others that need to follow suit. And again, we're happy to talk in the boardroom to get to those results, or we can see folks in the courtroom as well. But there is a symmetry, if you will, a matching, if you will, between the claims that we were making in court and the remedies that we could have secured and what we've secured in this settlement. The night block, the block on notifications during school hours and at night, the limit on duration, 2 hours or 1 hour if other industry players come on board. That is in perfect symmetry and harmony with what we were seeking in court. So this is a outstanding constellation of protections but there's always more to be done, and this is an ongoing effort that policymakers, AGs, and others will be part of for some time to come. But this is a breakthrough. This is a milestone. This is transformative, and we're proud of what we've accomplished today.
Thanks. So, are we to take it that Meta didn't that you didn't give up anything to get to this agreement?
Well, it depends on what you mean by that. We are always measuring our settlement results with our potential litigation results, not with respect to maybe what you're suggesting, which is everything possible under the sun. Are there other things possible under the sun? Yes. Are there things that we could have got better in our litigation? No. This is an amazing result. So when you say compromise measured against what we could get in litigation, we got the things that we could have got in litigation, and I'd say more. So the opposite of compromise. We, if you will, overperformed in our settlement and delivered more results to children and families and parents across the country than we could have got potentially in our litigation. But are there more things to do under the sun? Yes, and we'll continue to do those things.
Thank you.
Next question comes from Maria. You're now unmuted.
Hi. Can you talk a bit more about the phase two restrictions and contingent payments? I'm very interested in the other companies, Snap, TikTok, and YouTube. It seems that there are provisions of the agreement that appear to contemplate them accepting substantially similar restrictions. So have these companies already committed to those terms, or are there some talks going on with those other social media companies?
So there is a built-in design, as you mentioned, that's really important to us in this proposed settlement agreement with Meta that we hope the court will approve, that contemplate industry-wide solutions and their potential and frankly the desire and the intent to have those industry-wide solutions. And so there are some restrictions. One example is the limit of 2 hours of use per day. If that applies to just Meta, then it remains 2 hours. But if other industry players make commitments similar to what Meta has made here, then the commitment, the restriction ratchets up to 1 hour per day. And that is the hope that we will be able to get these heightened protections, these more significant commitments that they will kick in for Meta if and when we are able to secure commitments and agreements from other industry players. So I'm not going to comment on any current potential or even whether there are discussions with other players, but I will say, because this is public, we have a lawsuit against TikTok. We're going to be putting more time and attention and focus on that. We've already put everything that's needed and necessary, but with the momentum that we've built, the success that we've secured here, we will be focusing on the rest of the industry. This is an industry-wide problem. Meta is part of the industry, a major player in the industry, but there's a bigger ecosystem that we will not be satisfied until we address all of the problems in the entire industry. So we are going to focus on TikTok. We are going to focus on Snap. Obviously, we're already focusing on them to some degree. We're very concerned about YouTube. So my hope and my belief is that we will see commitments across the industry, and then the sort of phase two, tier two, the ratcheting up of commitments and conditions that are contemplated in this settlement agreement for Meta, that those will kick in as others in the industry also make similar commitments.
Thank you.
Next question comes from Elizabeth. You're now unmuted.
Thank you so much for doing this. I guess just big picture, do you see this as a big tobacco moment for tech? We've talked a lot about the stakes here. And how much do you look at this kind of big picture with other litigation still going forward against Meta and other companies, and that the fact that there are still lots of outstanding, as you just mentioned, lawsuits against TikTok and others, even against Meta too, and they're vowing to keep fighting? Thank you.
I know there's quite a bit of interest in drawing this comparison with tobacco. I think there are some similarities. There are also some limits to those similarities. I do think, just stepping back, regardless of whether it's analogous to tobacco or not, this is a major moment to clean up an industry that has been hurting our kids. And so, in the way that the impact of the solutions delivered in tobacco were good for health, good for kids, good for Californians and Americans. This is similar. It's great for children and families and parents who've been suffering. Um, it uh, it's similar in that fact that it's a number of AGs banding together, asserting ourselves, exerting our authority, demanding better, requiring accountability, and enforcing the law and delivering results. It's similar in that way. It's similar in the way that Congress hasn't been delivering and has left a vacuum and a gap so that the state AG stepped in to deliver. It's similar in that it deals with public health, different issues, but public health issues broadly. So yeah, there are some similarities, but I think there's probably also some limits to those similarities. I think the most important thing to focus on here, whether it's similar to tobacco or not, is this is transformative. This is momentous. This is a major step forward in the ongoing quest and journey to make sure that our children are safe everywhere, including online. And I got to just take a moment to say I have heard from many parents as we brought this case this morning, and with gratitude, but also relief. I think they feel safer today. I think they feel seen today. I think they feel protected today. I think they feel more confident in the future of their children. I think a lot of them are worrying and have been concerned about what's happening to their kid online, what Meta has been visiting upon them and imposing on them, and the harm that they are suffering from. I've had a number of AGs reach out to me and sort of take off their AG hat and just say, this is a big deal as a mom, as a dad. And I feel the same way. I'm the AG of California, honored and grateful for that. But the most important title I'll ever have is dad to my kids. And I am, as a dad, thankful that our AGs came together to deliver this. So I want to put it in those terms. It's transformative for moms and dads, and for kids, and for families, and for the mental health of the most precious thing on our planet, our kids.
Next question comes from Chris. You're now unmuted.
Hey, can you hear me?
Gotcha.
Thank you very much. It's Chris Woodward, the Center Square. Congrats on the settlement. Can you tell us what California may be doing with any money it receives from Meta?
Yeah. And again, high 1 billion plus to 2 point something plus, depending on what other members of the industry do. And it'll be not surprising what we do with that money. It's generally going to be used to what we call it usually abatement and mitigation efforts to address the problem of social media harms to the mental health of children. So it will help reduce the harm to children, help address those mental health issues that I've talked about, from anxiety and depression to body image issues to addictive tendencies to learning loss. We will be addressing the underlying problem here, which has always been with the money, which has always been the focus of this case, the mental health harms of kids, and helping make sure our kids are safe and healthy and protected.
Next question comes from Mike. You are now unmuted.
Hi, thanks for taking my question. It's Mike Swift at MLEX. Could you talk a little bit about the $17 billion figure? It seems a little arbitrary. How did you get to that number? What was the formula for it? And secondly, could you talk a little bit about the settlement negotiations? seems like the trial has been going really badly for Meta the last 2 days, to my eyes, and just wondering if that brought them to the table or if this is something that's been close to resolution for a long time.
Sure. So the $17 billion is, again, a secondary but important component of the settlement. We have always been focused on, we will always be focused on the injunctive relief, the changes in business conduct, the reduction in business practices that hurt kids. And we've delivered and then some in multiple ways, from the beauty filters to the likes that we're ending, to the night blocks, to the blocks on notifications during school hours and nighttime, the reduction in use, for daily use. All those are really the heart and the core of the settlement. And then there's the $17 billion that is going to be spread across the 51 states and the District of Columbia and territories. And it is an unprecedentedly high number. It is historic. It is, I think, the highest financial payment of its kind, way higher than opioids, higher than what the EU secured. So while secondary, it is also very significant. And we wanted to make sure that there was appropriate funding paid for by Meta to address the harms that Meta created. Meta created the harms. Meta should help pay for the mitigation, for the programs that will address mental health harms to kids. And it will go out to each of the states through a formula. So it is important that it be significant. And 17 billion is historically high and very significant. So we're grateful for that component of the settlement agreement, but it is not the focus. The focus is the injunctive relief, the changes to business practices going forward that will reduce the mental health harms to kids. And yeah, I think for anyone who's got eyeballs and is paying attention, the trial was not going well for Meta, and that is not dissimilar from how their other trials have gone. I think ours went particularly well for us and particularly bad for them, given the incredible talent of my team and our collaborative team of AGs from across the country. But having Instagram president Adam Mosseri, giving testimony as we settled was not random. I think they were dying to have him get off the stand. It was not going well for him after already devastating and damaging testimony by other witnesses, including a whistleblower who worked inside of Meta and knew exactly what they were doing and also what they didn't do, having knowledge about the harm that their products created for kids. So settlements take time, and this is obviously multiple states, the District of Columbia, territories, working with Meta, and we are always happy to explore potential outcomes through settlement if they meet our lofty standards, if they get the job done, if they deliver on what we're looking for, or we can get it through trial. And here we were sort of on a dual path where we were in trial. As you know, putting major witnesses on the stand, having Zuckerberg around the corner to be called, but we were also exploring settlement, and we were able to deliver through settlement in a incredible way that it was beyond what we could have gotten through trial. So we're grateful for how this all turned out with what we're delivering for kids and families and parents across the country.
Thank you. Next question comes from Ian.
Hi, thanks for doing this. Kind of just to follow on from that, you obviously had the verdicts from the juries in the other cases in the spring, and then you had this ruling from the judge in New Mexico pretty recently. How much did those outcomes kind of change the dynamics and open the door to a settlement and just sort of show that it was possible to win at trial and that maybe there was another door that Meta might want to take here?
Sure. You have to ask them that question to really get an answer. But from where I sit, you can't ignore the major defeats that occurred in a short period of time leading up to our major federal trial involving multiple states across the country. They took a major hit in Los Angeles, a major hit in New Mexico, with my colleague in New Mexico delivering that, and they got a chance to see what juries thought about their witnesses and their defenses. They got a chance to see how Instagram president Adam Mosseri and CEO Mark Zuckerberg performed on the stand, or perhaps maybe didn't perform so well. So they got a chance to turn theory and hypotheticals into reality, and see how they did in our court of law, where justice and accountability are delivered by juries and judges. And so I don't see how that wasn't in the back of their mind when they came into our, started the trial in our case. But every trial is different, and if we weren't prepared and didn't have our case tight and didn't have our arguments sharp and weren't ready to hold them accountable in court, then any case could be different. This case could have been their bounce back, where then they started defending cases and started winning, and could have turned things around. But because of the talent and commitment, preparation, and readiness of my team, I think the trial was heading towards probably their worst performance that they've seen in a court of law. And settlement is always informed by the ongoing litigation. And if you're having a bad day, or every day is a bad day for you in trial, that is going to affect settlement. So I think we had a wind at our back. We had a lot of momentum that we created with our preparation in our case and with our incredible performances at trial that helped lead to this very important, significant milestone result.
Next question comes from Cecilia. You're now unmuted. You have to unmute yourself as well.
Thank you so much, AG Bonta. So, you use the words historic, watershed, landmark. Certainly, the company Meta began its many lawsuits on social media addiction with like guns ablazing. They're very confident that when they talked a lot about the defense of Section 230. This feels like a legal breakthrough as well. Would you characterize it that way, in the sense that the legal arguments were COPPA and consumer protection laws with the states, and then the tort law on personal injury. So it's kind of like a get around of this legal shield that's protected the whole industry. Can you talk a little bit about that and the importance of how this settlement perhaps breaks through of what has been a pretty impenetrable shield liability wise for Meta and the other companies? I have another, but let's start with that. Thank you.
Sure. Section 230 and the First Amendment have been sort of defenses that Meta has often gone to, and they remain the laws of our country. Section 230 is a federal statute. The First Amendment obviously is in our U.S. Constitution. It's not going anywhere. And Section 230 and the First Amendment were advanced by Meta in this case as defenses, and they had a role to play in this case. And so I don't want to overstate where the First Amendment as a defense and Section 230 have gone. They still have ongoing durability, and I think Meta will go to those defenses again. But even given those defenses, we are delivering this result. We overcame them, got to trial, put witnesses on the stand, revealed the dangerousness of the products, the knowledge of those dangers by Meta, and they're lying to the public about it. We made our case despite those defenses, and we put Meta in a place where they made the commitments that they made in this settlement. You don't do that if you think you're going to defense the case on First Amendment grounds or on Section 230 grounds. So, but this case is a settlement. I just want to be clear about that. It is not a court order that is interpreting Section 230 in the First Amendment in some new or different way. It doesn't have presidential value that will govern, how Section 230 and the First Amendment are seen throughout the country. Those remain ongoing issues and challenges. But I think the biggest point to be made here is that Section 230 and the First Amendment are not impenetrable shields to holding Meta accountable. We demonstrated that today. Our settlement shows that. They advanced Section 230. They put up that shield and hid behind it and said, "You can't touch us." And we said, we see it differently. We think we can, and we did. So I think it shows the limits of Section 230 and the First Amendment in delivering, in the ability of the people, children, families who've been harmed by Meta's conduct to deliver justice and accountability. But I don't want to overstate it either. Section 230 and the First Amendment remain defenses that are available to Meta and others in the future. But we do believe that they are not invincible shields for seeking and securing justice, and we believe we can continue to build on the momentum that we've started today.
Great. And sorry, just the last thing I wanted to ask you, AG, is that did you, the sort of the setup of the settlement in terms of the different phases and contingency upon whether other social media companies settle as well? That's interesting to me. Did you set out with an industry-wide solution in mind? Meta uses the word in their press release that they've been partnering with you. Would you agree with that? I guess just trying to get a sense of how this came to be, this sort of ostensibly unusual settlement in terms of these contingencies. Thank you.
Yeah, I think the terminology is maybe contextual. If we're in court in this litigation, we're not partnering. We are very much their adversary, the opposing party. We are the plaintiff, suing them to seek justice and to secure a remedy that addresses the harms that they visited on our children. So that is not partnering when we're in the courtroom, when we're in trial, when we're taking President Adam Mosseri to task, and putting on our other witnesses. That is adversarial by design. Litigation is an adversarial process where opposing parties come to court and with the help, assistance of a judge and a jury to arrive at justice. But when you're settling, there is a level of partnership. You have to talk to each other. You have to be professional. You have to discuss ideas and land on agreed upon outcomes. And so there is I suppose, a level of partnership that is inherent in the settlement negotiation process, and that led to the final settlement. If Meta was disagreeing and disagreeable about everything that we wanted, we wouldn't have this settlement. They agreed, and so there is a set of common ground. I mean, they didn't agree voluntarily out of the goodness of their heart. We had a trial where we were hammering them. We had a litigation and a trial verdict hanging over their head, which was not going well for them. So I think agreement may be, or partnering may be in the eye of the beholder. But to your point about the design, I think Meta probably has a view about the industry and an observation about the industry that's true that we have, which is that Meta, while they are a major player in the industry and they have visited enormous mental health harms on kids through their products and their designs, they are not the only player in the industry doing so. And others rightfully must be held accountable. And so this proposed settlement agreement that we hope and believe will be approved by the judge contemplates that, steps back, and isn't just wearing blinders as to Meta's conduct and Meta's conduct only. It sees the bigger concerns and dangers lurking in the broader industry and accounts for it and addresses it and has a plan for it. And I think that's appropriate. I think while we hold Meta accountable and secure these very important commitments going forward that will reduce harm to our kids, we need to be aware of the other players that are also visiting harm on kids and have a plan for that. And this settlement agreement does.
Thank you.
Next question comes from Tyler. You're now unmuted.
Good morning, Tava Katzenberger here from Politico. Real quickly, can you just confirm whether or not you've had conversations with representatives from Snap, TikTok, and from Google regarding their potential participation in these terms?
On these specific terms that are in this settlement,
Yes.
this is hot off the press. So the conversations we've had about the terms in this settlement are with Meta. We've been working literally, day and night, sleepless nights for my team to get to where we are today. I think the concepts that are represented are not new to TikTok or Snap or YouTube. And we're in a lawsuit with TikTok. So we've definitely had communications with TikTok around our lawsuit and what we're seeking. We've also been in communication with other members of the industry, but I don't want to talk about the content, even the weather for some of those conversations to the extent that they may involve confidential components to them. But I think the most important thing is that going forward, what will happen. And we expect that other members of the industry, including TikTok, including Snap, including YouTube, while observing how some of their models are very similar to Meta, but also maybe different, will adhere to essentially a similar set of remedies and protections for kids and commitments. And whether we do that through litigation, through conversation and resolution, is really up to the other members of the industry. But we think that this is a really good blueprint for not it's an enforceable blueprint once the judge signs off on it, should she do so for Meta. But it's also, I think, an appropriate blueprint for what other members of the industry should do. So to those other members of the industry, if they're following here, they should take a close look at this settlement agreement and think about how they might want to make commitments to this blueprint.
And very quick follow-up. Should this agreement be seen as in any way precluding other states, including California itself, from taking further action through their legislatures, for instance, to regulate social media companies?
No, not at all. It's a floor. It is not a ceiling. Above this floor, these sets of commitments, legislatures, policymakers, our office, should it come to conduct that we see that we think is violative of the law above and beyond what's contemplated in this settlement, or even if there's violations of this settlement that's enforceable by the court. That's why, or hopefully it will be once the court signs off. Should the court, in its wisdom, decide to sign off here, we can enforce the four corners of this agreement and the terms of it. But no, this is not sort of what I think you might be suggesting, that it sort of preempts any other action in this space. Legislators are free. Policymakers are free to propose other ideas that address the concerns they have with our social media platforms vis-a-vis the harm they're visiting on our kids. So it is not preemptive in any way. It's a floor, conceptually, not a ceiling.
Thank you. Next question comes from Rachel. Rachel, you're now unmuted.
Hi there, Rachel Myro, KQED News. I was just curious, what about the other pending lawsuits, the state consumer protection COPPA lawsuits? Does this agreement, if Judge Gonzalez Rogers approves, does this agreement stop those, or do they proceed apace?
So thank you for your question. So let me just back up a little bit here. This is a 51 state, district, and territory resolution of claims from across the country. And when there were a number of different lawsuits brought by different states, the District of Columbia and territories, and some were part of this federal multi-state, multi-district litigation lawsuit that we were in trial for in Oakland. That involved 29 states, but other states, including Tennessee, for example, who's in trial right now, had their own lawsuits in their own states. And so this resolution is essentially a global resolution, with the exception of two states who didn't sign on, Texas and Florida. It addresses the claims against Meta with respect to COPPA and their version of unfair competition law or false advertising law. It resolves their cases. So it is a global resolution for all those states, the District of Columbia and the territories who've signed on of those cases.
Thank you.
Next question comes from Lisa. You're now unmuted.
Hi, Attorney General Bonta. It's Lisa Rubin at MS Now. One of the things I wanted to ask you about is about the injunctive relief in particular, and the fact that it puts a lot of control into the hands of parent supervisors of teen accounts to either live with default settings or allow their teens to change them. What level of confidence do you have that Meta, under this settlement, will actually implement the kind of screening methods to A, detect who is and who is not a teen, and then B, who is and who is not a parent, to the extent that teens are trying to circumvent these controls? I'd love to hear you talk about that.
Yeah, we're pleased with that part of the settlement, that there will be more robust age verification tools implemented going forward, as well as parent verification tools. And what we had up to now, we described in our trial, I think very accurately and powerfully, as tissue paper defenses. Meta made much to do about new approaches or safeguards, quote, I'll put those in air quotes, safeguards that they put in, many of which they implemented only after we sued them. So they seem to be performative and superficial and pretextual in response to our litigation. But that as it is, they were essentially quote unquote safeguards that were easily overridden by a child's own swipe of the finger. That didn't fly. That was unacceptable, and that will not be allowed going forward. We will have new parent verification. Meta will implement new parent verification tools where you need to a parent needs to be authorized and verified as a parent before there is any overriding of the defaults. So, a separate person who's verified and authorized, not a child who sees a notice and wipes it away with the finger and continues to engage, with the same product and features without any parent actually being involved. So, technology is always a potential limitation. Meta has shown an incredible ability to accomplish many things that it wants when it leads to an increase in their bottom line. We're confident that they can accomplish these age verification and parent verification features, and frankly, they're required by the settlement agreement.
Thank you. Next question comes from Jonathan. You are now unmuted.
Great. Thank you for doing this. Jonathan Vanny with CNBC. I'm just curious if Meta would have to make any additional changes, pay any other penalties, assuming the case against TikTok leads to a proposed settlement, just like how this proposed settlement includes some caveats related to what YouTube and TikTok might agree to. Just curious how that plays out.
Yeah. The answer is yes. So there's sort of this level up concept built in across the settlement agreement, where Meta is required today by this settlement and agreement, and regardless of what anyone else in the industry does, to do certain things and pay certain amounts. And if others in the industry make similar commitments, sort of if that industry trigger is pulled, if you will, where Meta is not the only industry player making commitments of this type, then they will do more and pay more. So the answer to your question is yes.
Got it. Is there, and then, another question, is there any reason why Snap is not involved in, the monetary side of this agreement?
Um, I think it might have something to do with the recognition of the market share that Snap has. But I'm not sure what you mean by that. Maybe I'll say that. This agreement
That kind of
is met.
that kind of answers my question.
Yeah. Okay.
Next question comes from Sarah. You're now unmuted.
Great. Thank you so much. Sarah Bloomberg with Agence France Presse. My question is, assuming that the settlement agreement is approved by the judge, if Meta violates the agreement, what types of enforcement actions are you able to take?
Yeah. This will essentially take the form, this settlement agreement, not just as a sort of, if you will, a private agreement between parties, the AGs on one side and Meta on the other. It will be an enforceable agreement by the court. And that was very important to us. That was a deal point that essentially was non-negotiable for us. We wanted a judge to oversee the ongoing compliance by Meta to the terms of this agreement. And so we will be able to go in court. We'll be able to enforce the agreement. We will be able to hold them in contempt of court. We will be able to have a judge with the judicial authority that judges have make orders and hold Meta to account. And that is a very important part of the structure of this agreement. If and I hope when the judge signs on, the full weight and authority of the judge's oversight will kick in to enforce the terms of this agreement.
Thank you. Next question comes from Ethan. You're now unmuted.
Hi, thanks again. And so you mentioned YouTube, and you mentioned this agreement being sort of a blueprint, and YouTube is often seen as sort of escaping some of the scrutiny that companies like Meta has undergone. And so you mentioned concerns about YouTube, and what are your concerns about YouTube, and 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 um, and to what extent do you think this agreement is more than a blueprint and is something that gives you leverage, that gives you sort of a stick to use in addressing the concerns that you have about YouTube?
So maybe first I'll say YouTube didn't escape accountability in the Southern California case. And YouTube, I think, is appropriately squarely on the radar of those who are concerned about social media platforms, features, and products that harm the mental health of kids. So YouTube is also not exactly the same in its model as Meta and TikTok. That we have to recognize that, but there are similar features and products that YouTube uses that are along the same lines that are designed to create excessive, compulsive use that lead to mental health harms, and most importantly, that hurt our children and can and should be changed. So whatever way you want to describe how things may have been in the past with respect to YouTube, I will respectfully say I think that's changing, if it is the way you say, because there is a concern about the whole industry, and YouTube is a major player in the industry, and we want industry-wide solutions. so that no matter what platform you go to, whether it be Meta or TikTok or Snap or YouTube, our kids are safe and they are not being preyed on by folks with sophisticated designs, features, and products that hurt our kids. That just shouldn't be. And I'm proud that we've had a bipartisan group of AGs stand up for that. So, is the blueprint something more? Um, I think that's probably in the eye of the beholder. We'll see how others react to it. Um, but I think this set of this suite of this constellation of solutions in terms of injunctive relief that we've delivered here that apply to Meta, I really think that YouTube and Snap and TikTok should be thinking very closely about them and their commitment to adopt the same. And it could be done in a really productive way where states talk to other players in the industry and get to a good place where they're delivering in the same way that Meta is through this enforceable settlement agreement for the mental health and well-being of our kids. Or it could be through trial. But I'll say from my vantage point, my office, we're proud and pleased about what we've accomplished today. It is momentous, and it gives notice to others in the industry that we're not done, and we expect similar outcomes from them as well. And there's a lot of ways we can do it. We hope we can do it by working it out with those other industry players and delivering for our kids as soon as possible.
Thank you.
And that was the last question.
Super. Thanks, everybody. I appreciate your engagement, your thoughtful questions, and the opportunity to spend time with you this morning. Take care. See you next time.